So our next session that we're going to do is aptly named the 7-minute thesis, and this builds upon what we've already learnt today. We're taking a closer look at the research and academic works of 3 postgraduate scholars. First up, we have Etienne, who's Malaysian Chinese in Pakeha and has been thinking about the place of Asian peoples in Aotearoa for some time. Through studying Te Tiriti at Te Heranga Waka, Victoria University, he became interested in the phrase tangata tiriti and what that might mean for all tauiwi settlers in Aotearoa. He's currently in his first year of a PhD at Victoria researching that question. Next, we have Jess. Jess is a human rights lawyer and advocate. She's passionate about bringing light to issues that impact vulnerable communities in Aotearoa. And today she'll present a brief presentation on how the joint venture have designed a national strategy and how well Asian voices were captured within that document. And lastly, we have Amarind. Amarind is the son of Cambodian refugees who fled following the horrors of the Pol Pot regime. Going through law school, he's always been interested in human rights and the law, and where Amarind is a graduate from VUW, where his final honours year was wound up in exploring judicial colonisation, one of the many topics that sort of led for the need to this network, he's going to consider what is a reasonable person. All right, Etienne, why don't you come on up, and then you can start things off and get your presentation up on the screen. Scotch. Here we go. Let's get this one up here. Just keep it up.
Kia ora. Thanks, Teja, and kia ora tātou. Yes, my name is Etienne, and as Teja said, I'm studying tangata tiriti, which is my joy and absolute pleasure. Really lovely to be here today. I'm just going to check. I press this. We're going to get the next slide. No, we're not. What if I click here? Yes. Brilliant. That's my photo. That's the same shirt, incidentally. When I came in today and was listening to the first few presentations, my first thought was, crap, earlier speakers have covered a lot of the content I was going to cover. But I thought instead, silver lining, I get to look at it from a slightly different lens to what other people have been talking about. I'm looking at it through the lens of this idea of tangata tiriti. And so many of us will have heard this phrase before, especially in activist tiriti-based groups, also potentially if you work in government might be a familiar phrase. But I've also found that when I ask someone what they think tangata tiriti means, they might be able to give like a 1-sentence answer, but not be able to explain anything more. This is specifically talking to tauiwi settlers about this concept. Also, people might have different perceptions about what this means. So I thought, why not do a PhD about it? And here we are today. So I'm going to start off with a slide on the status quo, which has already been covered very well by our earlier speakers. But I do want to bring out a few quotes at least. This first one, modern day Aotearoa has been described as demographically multicultural, formally bicultural, and with few exceptions, institutionally monocultural. And that's from psychology professor James Liu. And so we've got these buzzwords, multiculturalism, biculturalism, monoculturalism. All of these have problems to them. I mean, monoculturalism especially, why would we want one dominant ideology framework imposed over all of us? Multiculturalism, unfortunately, not that much better. There's been a lot of criticism of this idea of multiculturalism, especially in that it discriminates against Indigenous peoples, making them just another minority under the crown, which, you know, I don't like, you might not like. Biculturalism also has some problems with it. I've got this second point here. There's a large school of dissatisfaction with ideas like treaty principles, treaty settlements, Crown Māori partnership, even the incorporation of tikanga Māori into the state law. This may not be a perspective you've heard before. If you're interested, Ani Mikaire, Moana Jackson, Annette Sykes, and a bunch of other really cool people writing on this. Got a beguiling little quote here though, which I will read. So this is Ani Mikaire talking about how treaty principles have been used in court judgments. She says, reliance on the principles of the treaty in order to describe the relationship between Māori and the Crown leads us down the murky path of partnership, whereby tino rangatiratanga is made subject to kawanatanga through such euphemistic contrivances as reasonable cooperation, good faith, and reciprocity. So just drop that little bombshell there, and you can think about that in your own time. Also, the status quo is far from ideal for us tauiwi of colour as well. We've talked earlier in the day about feeling sidelined when the debate's been about, Māori Pākehā reconciliation journey or treaty journey, and it makes us Asians and other tauiwi of colour wonder, where do we fit into this as well? And so, this next slide, there's this idea of tangata tiriti, which arrives as a gift from Te Ao Māori through to tiriti to us tauiwi. Notably, it came up in Chief Judge Iri Taihakure Jury's Waitangi Day speech in 1989. He said, we must remember that if we Māori are the tangata whenua, the original people, then the Pākehā are the tangata tiriti, those who belong to the land by right of that treaty. One of the questions you might immediately have looking at that speech is wondering if the term tangata tiriti could apply to more than just Pākehā peoples. And so that is one of my questions. This was meant to read 1, 2, 3. Unfortunately, it just reads 1, 1, 1. Don't call the police. But the first question, yes, who are tangata tiriti? Who is this group of people? Might it be wider than the term Pākehā, but also hopefully the question goes a bit deeper than that. These are questions I'm asking in my PhD research. Secondly, what rights and obligations are associated with tangata tiriti? If we're here now, what does that mean? What should we be doing? Etc. And what does the idea of tangata tiriti mean for Aotearoa's future? Here we go. So first, who are tangata tiriti? So I plucked this particular definition from Network Waitangi Ōtautahi. They're a tiriti-based tauiwi activist group operating in Ōtautahi, Christchurch. And they've got this on their webpage. Tangata tiriti includes everyone who cannot whakapapa to a Māori ancestor, not just white people from Britain, as it's not an ethnic term. This goes some way to being a definition. I tried to look further on their website though for supporting evidence for this, or some more information about where this term's from. This was most of what they gave in terms of a definition. I kind of as a researcher, I kind of want to use a legal word, due diligence on this concept. I want to know, where it's come from, who else has used it apart from Chief Judge Eddie Jury, and can we come up with better definitions than these? Looking at tikanga Māori, looking at some of the international treaty-making literature, maybe interviews. As a side note, you might have heard Darren call Asians tangata ahia, when he was giving an introduction earlier. Maybe a term that we could use is tangata tiriti, no ahia, tangata tiriti from Asia, but that's just me putting that out into the void and wondering for now. What rights and obligations are associated with tangata tiriti? I'm going to have to speed it up here. I'm not going to be able to read everything off this slide. But first of all, when we say rights and obligations, not just universal human rights. What does it look like from a Te Ao Māori point of view, with rights that start in tikanga and then are expressed in te tiriti and then in these international standards? Maybe the pōwhiri process has something to say about our relationship with tangata whenua. There was that quote from Moana Jackson earlier, which I'll repeat because it's great. Te tiriti o Waitangi for me welcomed people from somewhere else onto our marae. You are welcome, you can live your lives as who you are, but this is the basic kawa, that you will respect the rights of others, you will respect the land, and you will work together to make this a better place. So some things about obligations in there, some things also about potentially like a right to belong. Again, those who belong to the land by right of that treaty, as the jury has said. Finally, what does the idea of tangata tiriti mean for Aotearoa's future? A lot of this, again, has already been largely covered, but one thing, I'll speak mostly to the first one. One thing that made me interested in this is this idea, Te tiriti o Waitangi between Māori and the Crown, that's something that people are familiar with. What about Te tiriti o Waitangi between tangata tiriti and tangata whenua, decentering this idea of the Crown? Maybe we just put it off to the side there and get rid of it. Maybe it's the tangata tiriti and the tangata whenua who should be at the centre of this relationship. And maybe this leads on to constitutional reform as per the Mātiki Mai report. Especially interesting is what would the place of Asian peoples and other tauiwi of colour be within such a system? Are we just going to Control-C, Control-V the Crown as it stands and then have a tino rangatiratanga sphere potentially? Or is there work to be done within the Crown sphere to change things up, because it's probably not ideal? And also migration reform, another important point that's been raised before. Because tangata tiriti are all migrants. You might go back a few generations, but we all are migrants. And so what does that mean for how we look at migration law, for example? How we arrive into a country definitely affects how we carry on. Maybe all law is actually migration law. Have a think about that one. So, he kupu whakatepe, just closing words here. This is a complete work in progress. This is at the start of my PhD. I'd love feedback. I'm open to any and all feedback. I love having conversations about this, so please hit me up. And finally, I'm very excited for this journey and for the future of Asian peoples in Aotearoa. So, tēnā koutou katoa. Thank you very much.
Sorry, just sitting up, just bear with me. All right, kia ora everyone. My name is Jess. I'm here to discuss very briefly with you all about this really cool and somewhat visionary idea of a national strategy behind the elimination of family violence and sexual violence in New Zealand. And what this means for Asian women and whānau. So as at December of last year, 2021, the joint venture, who I'll go into in a minute, have released a national strategy which will outline a 25-year plan in terms of trying to tackle some of the problems and risk factors that contribute to our atrocious family and sexual violence. I think we are one of the worst in the world. So this report is called the Te Aorere Kura, and the purpose of the report really is, or the strategy rather, is to really be a guiding light for Asian women in whānau and all others. So we're just going to look into the strategy recently released. I call this my thesis 2.0 because when I wrote my thesis in 2020, the national strategy was still in development. So I was really excited in preparation for this session to see that they have now done a strategy and what that means for us as an Asian whānau. So I'll start off with just gently introducing the joint venture. So who are they with this JV? Everyone's talking about the JV. So they are a collection of at least 10 ministries and government agencies established in 2018, committed to working together to reduce family violence and sexual violence in Aotearoa. So this is really about coming together and avoiding this siloed response to family violence and sort of like trying to sort of attack family violence from a multifactorial perspective. So it's really about looking at the various ways that each government agency can contribute to reducing family violence and working together as a collaborative effort. Here are some of the things that they have committed to. One of them being really having a lead of a whole of government response to reducing family violence, and where my thesis focused on. So I won't go through all of them, but my thesis really focused more on the designing of a national strategy and action plan to reducing family violence and sexual violence. So if you want to check out who the joint venture are, I've added a little link down here, which you can see in your own time. So just coming to this Te Aorere Kura national strategy, like I said, it was released in December, so it's brand spanking new. So if you're interested in reading a little bit more about it, again, I've added a little link there for you. So again, like I said, it really is to shine a guiding light for all those who have been impacted by violence. And this is not just necessarily a victim-centric strategy, although a big part of it is, but it's really also geared at like, assisting or like holding perpetrators to account. How can we, really break these chains of generational violence that seems to pass down from generation to generation? And so apart from holding people to account, it's also really about providing a beacon of hope to people and communities who may want or need it the most. Bringing about an energy and knowledge, and this is from a multicultural perspective. We are now sort of moving away from these really westernized Pakeha model, and we are wanting to move towards a culturally competent response. The strategy is available in different languages to make it more accessible to others. So when I wrote my thesis, unfortunately, I didn't really have wasn't very optimistic when I wrote it. And I not usually pessimistic, but when I wrote this thesis, I sure was. So the first hypothesis was that I was, really tautoko the establishing of the joint venture and what they were about. But my concern was really about the fact that there was really very little data on any ethnic minority group that was outside Maori and Pacifica. And so there was hardly any statistics on Asians. And so how can we design a response or a culturally competent response to address factors of violence if we don't even know like what issues impact these communities? And a failure to adequately consider these needs could risk locking these groups out of a culturally competent response. So where do these people go and how do we help them? And in terms of holding the state to account, I looked at strategic litigation as an option for doing that. So bringing claims under Part 1A of the Human Rights Act, which is really sort of like within our power at the moment. It would be a discrimination claim against government agency or even the joint venture as a way to do that. So in terms of the national strategy, how does that, how does that address the inadequate data issue? When I wrote my thesis, again, hardly any stats. And this has been acknowledged by Te Aorere Kura. There has been a state acknowledgement that, you know what, we're woefully behind on this. And not having enough data could really lead us to some really gnarly outcomes. I mean, we could be designing policy based on bias or implicit bias. We could be making terrible funding decisions without, any evidence-based, designed to like inform our decisions. So we should be very careful about that. And so collecting, designing, learning and monitoring systems is really the first place to start. How does that look like? That would really that would really rely on a lot of community engagement and like building trust in these communities so that we can get that data and we can invest in monitoring going forward so that, the data doesn't stay static. We can use it to continuously build and learn and improve, reduce structural discrimination for Asian minorities in Aotearoa. So what is the commitment for a culturally competent response for family violence? Currently, there's a lot of focus on groups like Māori and Pacifica, and this is rightly so because they are at risk. And so it is important to address these groups and to have culturally competent responses. But at some stage, it would be really great to see a culturally competent response extend to Asian groups and Mela and other ethnic groups outside the Māori and Pacifica ethnic groups. While there's no expressed commitment to do it at this stage, it might be really great to see this happen at some stage, just because it is a fact that Asian women in whānau do deserve access to culturally competent services. So we'd love to see more consultation, investment, and bridge building with these communities down the line. So in terms of claims, I won't talk too much about this, but basically you can bring discrimination claims against the state. This is mainly brought under Part 1A of the Human Rights Act. And yeah, basically Section 19 of the Bill of Rights Act was first heard at the Human Rights Review Tribunal. And you can, I'm not sure how I'm going on time, probably well over, I'm sorry. You can have a look at these cases that I've suggested, Atkinson and Adoption Action Incorporation, because these are like quite two good class action type cases that have been taken at the tribunal challenging discrimination on a prohibited ground under the Human Rights Act. Now, could we see something like this somewhere down the line for a failure to cater for Asian groups in a culturally competent response? We could, but my suggestion would be for us to wait and see. Now that we've got this strategy, it would be great to see the subsequent action plans that come forward to see how well Asian groups are captured within those plans. But if we do see that there is a trend that Asian groups are continuing to be sidelined or ignored, then strategic litigation could definitely be an option to correct that omission. So what do we think of final summary point, the Te Aorere Kura national strategy? Could it be a guiding light for Asian whānau and women? I think it definitely has potential at this stage. However, subsequent action plans with follow through would be really great to see, how well this translates in reality. And yeah, I mean, actively consulting, taking charge. This is maybe a really great space that the Asian Legal Network could think about getting involved in. And yeah, just having faith that things are changing, but we sort of need to be a part of that change as well. So thanks very much. That was my short little brief. I will hand over to my learned colleague, Amarind.
All right, it'll be fine. Let me just set up. Okay. Kia ora. My name is Amarind, and I whakapapa back to Cambodia, as I was mentioning before. I was born and raised in New Zealand, and I am eternally grateful to my parents and my supervisor for giving me the confidence to tackle this topic. So this is going to be my game plan. I'm going to describe judicial colonization to you all with the what, why, the who, the law, and my summary analogy in 7 minutes. So first up, what is judicial colonization? So it is when a judge applies sort of one perspective, one cultural legal norm onto another group of people when it may not be appropriate. And you can see that best when you apply what's called the reasonable person test. Now, the test is interesting because of its apparent objectiveness, yet we know that one size shoe does not fit all. Because I'm sure we can all agree that if a court declared a reasonable person would scream their intimate secrets to the world because they would rather not bottle it up, I don't think that judge probably would have considered New Zealand's depression statistics. But this exact fishy one perspective view was framed for 3 cases in criminal law: Aran Wang, Chayan Na, and Aran Zo. And all 3 cases dealt with women in battered relationships where each claimed they killed their spouse in self-defense. Yet the court expected these women to suddenly speak English and explain their abuse to strangers next door. Now, what academic scholarship and personal experience tell us is that East and Southeast Asian families are not very well known for parading their mental health issues to the world. In fact, it often carries guilt and shame. So I knew that these judges in these 3 cases clearly missed the mark in framing the reasonable person test, probably imagining a Pākehā person in the shoes of East and Southeast Asian people. So in other words, imposing a Pākehā person into the shoes of an Asian person, judicially colonizing these 3 women. Second, why should you care? Well, because the reasonable person test is what we call a universal objective test. It applies everywhere in the common law, from contract law to public law. Yet if New Zealand is to respect our bicultural history and our multicultural reality, as Justice Joe has previously put it, then we need to reshape what we think of as a universal objective test. Now, a misapplication of the reasonable person test could lead to a good outcome for Pākehā people, but it could lead to very unfair outcomes for our minorities. And this is problematic in a criminal justice system that is supposed to be blind, allegedly. So, who's an example? I want you to step away from the law for a moment and to focus on a particular person. And I want to introduce you to a woman called Ms. Chai. She is a Cambodian refugee who fled Pol Pot. By a stroke of good luck, Ms. Chai's first name is Moi, the same as my mum. Now, like my mum, she was a superwoman. She survived Cambodia, she started a new life in Sydney, and was utterly devoted to her friends and family. Now, this is not a photo of Ms. Chai, just to put it out there, but I would like to think that she was someone like this woman, who, after the horror of killing fields, found some happiness in her life. However, Ms. Chai was a battered woman, and her husband had a history of severe abuse. Now, it started in Cambodia, continued in the refugee camps in front of strangers, and continued again to their new homes in Sydney. Now, Ms. Chai described herself as perpetually terrified, constantly second-guessing his mood, and that the one time she had tried to escape from him to a church, she was turned away and was severely beaten when she got home. Now, remember, for her, seeking help outside the household is a taboo, a point lost for many people who don't understand the nuance of many Asian cultures. And this continued for years, gradually chipping away at her self-confidence and leaving her a broken shell, or a battered person. Then one night, after a particularly severe beating, Ms. Chai thought he meant it when he threatened to kill her when he awoke from his nap. Now, she believed that no one was coming to save her when he awoke, and no one cared. And she had to do something to protect herself. So she picked up a knife and she killed him. When she was tried, she claimed she was acting in self-defense. The court declined. So, fourth, what is the law? Well, let's turn our minds to the actual law. Self-defense reads like this, but relevantly for our purposes, the third requirement is that given the circumstances that Ms. Chai thought she was in, is what she did reasonable? Now, the court gave reasons, but relied on imminency as the reasonable requirement for requiring self-defense. In essence, you can only reasonably rely on self-defense if you were imminently in danger. But this is a judge-made test applying what they thought was reasonable, not a statutory requirement made by Parliament. Now, the court reasoned that because her husband was asleep, she couldn't justify using legal force against him. Ms. Chai, on the other hand, argued inevitability. Surely, if an attack is imminently coming, you should be able to act first, because after he woke up, he was coming for me. So the debate came down to those 2 points, right? Should self-defense only be available if you are imminently attacked, or also if an attack is inevitable? So let me illustrate this in an analogy. If there's a bar fight between 2 equally strengthened people, it would make sense for imminence to apply. But in a battered relationship, which is what Ms. Chai was in, where one party is vulnerable, her, and the other party is overpowering, her husband, then asking a battered person to wait for their abuser's attack before they can act is a death sentence, and ignores the reality of victims of domestic violence. So what should the law do? Well, as one member of the bench put it to me when I interviewed them, apply some bloody common sense, right? The Law Commission recommended twice to adopt inevitability as a test alongside imminence, because that was, ironically, the reasonable thing to do, per the Law Commissioner who wrote both of those reports. Now, in this world, Ms. Chai, who genuinely believed an attack was inevitable from her abusive husband, would have been able to act in self-defense. And the court may have allowed the defense to go to the jury, and perhaps the outcome would have changed. So let me take a step back and think about what a culturally competent bench could have looked like. It just means that it's a group of judges or a bench who appreciates that universal objective tests, like the reasonable person, are not actually universal, right? Sometimes imminency doesn't actually make sense in self-defense cases. Because if we're going to ask what a reasonable person would do, let's consider the person's actual circumstances. Because pragmatically speaking, I want to challenge you to think about this. What could Ms. Chai have done? She was beaten for trying to flee, punished for staying, failed by the state when she tried to ask for help, and she had children to protect with limited English ability and no support. If her primary worry each day was when her husband might kill her, what do you think the reasonable thing for her would have been to do when her husband threatened to kill her when he awoke? Now, I stress that having a culturally competent judge does not mean the outcome might have been different. It just means that when we're applying the law, we can take into someone's whole being and assessing whether or not what they were doing was reasonable. So if I let myself dream for a moment, what would the world have been like if the bench were culturally competent in her case? It would mean a courtroom which understands the things that she knew, but she couldn't articulate or tell. That she was a victim of a horrific past, carried a generational burden of surviving a genocide her friends did not. She was dealt an unfair hand by the universe, and I want a world where Ms. Chai knew the system wasn't stacked against her, that she didn't travel from open injustice to systemic injustice instead. A culturally aware approach to reasonableness would make a world of difference in a judge choosing inevitability over imminence, because that is their choice. It is a common law decision. So let me tie this up in one simple analogy. If the one thing you take away from it is this: being culturally competent just means knowing that when you visit an Asian household, you take your shoes off at the front. I don't know why, I don't know how to explain that, you just know it. And while some people don't do that in their homes, if you're visiting an Asian home, you should respect that. We should respect that. Thank you.
It's really great. Hey, thanks a lot to all 3 of you. Those were excellent presentations. And obviously, like, you know, as we mentioned earlier on, you know, research and thinking about these questions is one of the key parts of the ALN, so I'm really excited to see where you guys go. Before you leave, I do have a small token of thanks as well.